So USCIS is taking over 31 months to process I-601 waivers. They're taking over 18 months to process certain work permits. It's time to fight back. A major class action was just recently filed to challenge the long delays of this 601A hardship waivers. Why? Because that's the only thing they understand. Hello everybody, and welcome back to Immigration Channel. This is a place where you get the most up-to-date immigration news, immigration information, and everything else that you need to make your immigration journey less stressful. In this video, we'll talk about the most recent litigation class action lawsuit that was filed against immigration because of the severe delays of the 601A waivers. I'll explain to you what these waivers are, but it just shows you that when something is taking 31 months as opposed to 4 months, where they used to take those same applications before 2018, this is just crazy, and it's a trend that will go for other applications as well. So we'll talk about all this in the video, what can be done, why it's happening, how these lawsuits help. So if you're stuck with your case, at least you get some hope. So make sure you watch this video all the way until the end. Before we jump in all this, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of my videos, and also give us a big like so YouTube can show this video to more people just like you. So, 601A waiver delays been horrible for a lot of people, and on January 23rd, a class action was filed by the American Immigration Lawyers Association as well as a few other lawyer groups. They came all together helping about 250 plaintiffs that all went through the same visa delays. Now remember, these waivers are now taking over 31 months to process, and it took only 4 months around the end of 2018, 2019. If something can take 4 months to process, why they are taking almost 2.5 years to process this kind of application? It's unreasonable, it's unfair, and therefore these lawsuits are being filed. The beautiful thing about these class actions is that it's going to cover all applicants who are going through the same process. Anybody who filed their waivers before July of 2021 and they are pending are going to be able to benefit from this lawsuit if they win. Some applicants continue to file individually, but it doesn't necessarily have to be the case. If you have a pending waiver, you could still benefit from this litigation. If you remember, recently the government settled another class action with respect to H-4 EADs. They were able to resolve that as well. So these lawsuits do work, whether you're part of a class or you join individually to file the government because your case is being delayed. Federal courts are looking at these lawsuits and they're saying it's unfair for the government to continue to delay these people, to continue to cause hardship for these families who are waiting to be reunited, and therefore they're adjudicating in favor of these plaintiffs. And therefore you can see that these backlogs continue to grow, and they will continue to grow probably at least through this year and maybe even next year. And therefore, if you've been pending for over 2 years, if your cases have been stuck, you definitely need to consider litigation, the mandamus lawsuit. If you're not joining any of these class actions, you can do this on your own. And these lawsuits actually work because it's unfair for people to wait beyond processing times. It's very important that if your case are pending, are stuck beyond the regular processing times, litigation is going to work. And in 2023, filing these lawsuits is going to be really, really important to advance your case. So what are these 601A waivers in the first place? So typically when somebody comes to the United States, if somebody came here without an inspection, without a visa, and they overstayed, they work here, they marry your citizen, if somebody doesn't have proof that they were inspected legally to come into the United States, they will have to eventually leave the country and adjudicate their visas at a consulate, embassy overseas. The problem is that once they leave the country, they're going to be barred for 10 years. And at that point, unless there is a waiver, they're not going to be able to come back to the country. So the 601A waiver is a waiver that waives only one thing. It waives the unlawful entry to the United States and stay here. It doesn't waive a misrepresentation. It doesn't waive any criminal issues. So a lot of applicants, all they have is this one thing, that they came here unlawfully and they stayed here. And so these waivers can be filed inside the United States, and only once they're adjudicated, an applicant will go to the U.S. Embassy and come back safely with their green cards. The problem is that it's taking so long, almost 31 months for these applications to be adjudicated, and these families are not able to have closure. They're not able to know what's going to happen. What happens when my spouse goes to the U.S. Embassy eventually after 31, 32 months of wait? What if they're going to get denied? What if there's going to be more complications? It's just unfair. It creates a lot of anxiety, a lot of issues in these families, and therefore this class action was initiated, and hopefully we're going to see some positive results. We've seen also clients from our office as well where we filed these individual lawsuits to help them get through the backlogs, and in many cases they really work well, and within a few months the USCIS makes a decision on these waivers, and then the clients can move forward and go to the US Embassy and get their visas. So what's the next step in this case? There's going to be a motion for class certification. The government may challenge this, but the teams of lawyers are going to continue to fight until the federal court will rule in favor of the plaintiffs. Remember, the reason why it's so important to discuss these matters is when you see applications that are pending for so long, 30 months and more, it is unreasonable, it is unfair for applicants to suffer so long, and therefore it's good to see that litigation can help. And once again, if you're stuck, if you are going through this hardship with any of your cases, whether it's work permits, your actual green card, your waivers, or even your employment-based green cards or visas, litigation works. And in 2023, we are committed to fight for our clients and help them get out of these situations. So if you do need help, please text me 619-483-4549. I'm here to help you. Thanks for watching this video, and I'll see you in the next one.